Okay. Okay, up in the left-hand corner of your screens, you will see that our meeting is on YouTube. That satisfies, I believe I've said this many times, but to say it one more time, that satisfies our obligation to make certain that the court's business remains open and accessible to the public. And I will take us off of YouTube prior to concluding the hearing. And I believe that should have the effect of stopping the YouTube proceedings or the YouTube streaming so that it will not forever be on YouTube. So today is April the 14th, 2022. And this is Bataski Bailey versus American Family Insurance and others. And this is 2020CV340820. I have it calendared this morning for a hearing on the defendant's motion to quash subpoena, motion for protective order, motion for costs and brief in support thereof. If there are other matters that you think we're going to be dealing with this morning, tell me. But that being the defendant's motion, I'll ask if they want to go forward.
I also believe that there was a motion for sanctions and a motion to compel that was also due to a right for a decision as well.
Okay, I did see that on the docket, and if that is to be heard this morning, that's fine. I think, are they the mirror image of each other? Does it have to do with the deposition?
No, they're two completely different issues.
Okay, let's see which was first in time.
I believe the motion for sanctions filed by plaintiff, Your Honor, and we are ready to argue that.
Okay, Mr. Bailey, would you like to go forward then?
Yes, Your Honor. So there was as this court is aware, there was a prior motion to compel. That motion to compel dealt with the refusal by defendants, Fair and Walker, to make available individuals for deposition and testimony. The court found that there was no legal reason for them to prevent me from testifying, but didn't order any sanctions or anything at that particular point. Subsequent to that, I issued another set of discovery requests. During that discovery period, responses were had by defendant Fair and Walker as well as defendant Access Management. Those discovery responses were absent a lot of information that I had been made aware of during my investigation. As a good faith measure and pursuant to the rules requiring that I meet with them and have a conference prior to filing a motion to compel, I did so. I spoke with Mr. Mitchell and we had a conversation at length regarding potential emails and other information that had not been turned over. He indicated he would again look for any additional information and provide it if he was able to locate that information. No additional information to that point had been turned over. And as such, I filed this particular motion for sanctions and motion to compel. Within that motion for sanctions and motion to compel, I included approximately a snippet of what I was able to discover, 200 emails that the defendants had not turned over that were included or should have been discoverable within those requests that were sent to the defendants. Within those emails, if I may share my screen, I want to show the court one of the emails that was relevant, if that's okay with the court.
Sure.
Okay. Can the court see that?
I can.
You say you can or can't?
I can.
You can, okay. So this email in particular, this is listed as Exhibit G in that motion. It is an email from Miss Anissa El Amin. She's a unit owner here, Unit 34 at the Fair and Walker community. The issues the issues within this complaint or within this litigation revolve around the inability for me to have a repairs maintained by the community as per the declarations. This particular email indicates that for a period dating back to 2017, board members as well as other unit owners were having a very similar issue and were expressing serious concern. And even this particular email, the board member threatened to leave the board because of the board's failure to adequately address a lot of the concerns by the community. This particular email, I think, is pivotal to proving the elements necessary within my complaint. And it was intentionally, I believe, intentionally excluded from the discovery. And there were several other emails very similar to this. And again, I would remind the court that there were approximately 200 emails that were excluded that I was able to discover, all addressed to either the board members, to their personal email addresses, or Access Management as a management company. All of those emails show those within the sent and received caption. So those emails would have been easily discoverable, easily searchable by both defendants. As such, I was asking for this court, based on this willful and intentional act, the court has authority based on Gropper v. STO Corp. It's a Georgia appellate case, 272-623. It's a 2005 case, as well as Rivers v. Almond. Both give the court to impose sanction, including dismissal of the defendant's answer, or striking rather of the defendant's answer as a sanction for intentional actions of evading the discovery process and refusing to turn over relevant documents. That in my oral testimony or oral argument, in addition to the filed response, I would like the court to consider that as my argument.
Okay, thank you. All right, who'd like to respond?
I will be, Your Honor.
Okay.
I guess to kind of clarify everything here, Mr. Bailey sent his 6.4 letter in this case around December of 2021. We had actually supplemented our production and produced several hundreds of these emails in connection with an August, I believe, 2nd discovery, both supplementation and response, because Mr. Bailey has sent multiple requests for discovery, and we've responded to each one timely. And I think, as laid out in our brief, one of the key issues here is when we asked him, well, hey, what are we missing? What haven't we provided you? He said, listen, I know of emails regarding complaints of leaks in he listed about 10 units. But the fact was, we had produced emails related to those complaints of those 10 units. So we said, Mr. Bailey, in the document production that we're looking at, we have produced these. Where's the disconnect here? And he had stated that, well, while he had received our original discovery production via a secure link over a cloud-based transferal, for the August 8th or for the August 2nd one, he had not received it and could not access it. And so he admitted that he had not even reviewed the documents that we had sent him in connection with his discovery responses, which include these email complaints that he's saying are at issue today. When he said,
was this a situation, Mr. Mitchell, where the link expired or anything like that?
I can't, and so possibly, but after he said, I can't access this link, we sent him another link. And then he said, well, I can't access that link. So we said, okay, well, can we give it to you a different way, via Dropbox, via Google Drive? And Mr. Bailey said, no, he refused to take the documents via that method. He wanted them via hard copy. So we said, okay, we put them all on a thumb drive, and we mailed the thumb drive to Mr. Bailey. Mr. Bailey then said that the documents were inaccessible on the thumb drive, and that he wanted us to print all of the documents out and send him a giant paper set of the documents. We thought that was relatively onerous, especially when we produced it several times already. So, he also demanded a right to come and review the documents in our office. So we said, listen, you can come to our office. We will have our IT team confirm that these documents are all accessible. We'll give you the thumb drive, with the documents on it, and then you can have the documents and review what we produced. And I think his objection to that was, well, thumb drives can have viruses on them. And so he didn't want to take a thumb drive from us because then it might infect his computer. So he demanded that we produce everything, these, hundreds and really thousands of emails and documents via paper form, and that would be the only way that he would accept it. And at that point, we said, listen, we're trying our best in good faith to produce discovery to you, but the additional cost and time and effort of that doesn't equal basically the need for it. We're producing it either via the cloud or via thumb drive. So that's kind of the key issue that we think for his motion, and we think why it should be denied is because we have given him a large amount of these documents already. And it's been quite the process, Your Honor. There's been several board members over the period of time that he's requested these documents. There's been several managers of the access management, the management company, and putting these all together has put quite a strain on both of my clients and on us, to be honest. So we're doing our best in good faith to produce these documents, but Mr. Bailey isn't accepting them. And now he's filed a motion for failure to produce documents that he hasn't even reviewed. So that's why we're asking that it be denied, Your Honor.
Okay. Anybody else want to speak on behalf of the defendants? Okay, Mr. Bailey, would you like to respond quickly to that?
Yes, Your Honor, I'll give a brief response. So Mr. Mitchell is actually conflating two different issues. At the time that the motion to compel was denied, or excuse me, was filed, there hadn't been an issue with accessing the documents. That didn't occur till much later, right? So at the time, and I believe that it's his testimony at this point, that they had produced emails, the emails in relationship to what was presented in this motion to compel that were similar or the same. That is simply not true. The emails that were the 200 emails that was presented in this particular motion or referenced in this particular motion, at no point had they advised that the emails were in their possession or anything of the such. They had not produced those emails or hadn't produced anything similar to the emails that was produced. Lastly, I'll address the emails don't involve people that no longer work for the board. All of the emails, the 200 emails referenced in this particular filing, are still current board members. These individuals work with Mr. Mitchell and his counsel day in and day out to find these emails or discover the information relevant to these requests. So in fact, this isn't about whether they have to go searching for individuals that they no longer are in contact, etc. These emails are all from individuals that are currently on the particular board. And lastly, I'll just say to the court, the fact that these emails were easily obtainable by me, and it was only obtained after Mr. Mitchell indicated that he couldn't find any additional emails, indicates that they could have been discovered very easily by them. Again, I point that all of the emails were either from Access Management's email system or the individual current board members' emails. And so that makes it very easy for Mr. Mitchell to obtain. Thank you, Your Honor.
Okay, so here's what I've got.
Your Honor, I'm sorry, if I could just clarify one quick issue.
Okay.
Mr. Bailey has requested documents from 2015 to present. There are at least 2 individuals that served on the board during that time frame that are no longer on the board.
Okay. All right. So here's what I'm hearing. Not uncommon. I'm hearing one side say we gave it to you. I'm hearing the other side say you didn't. So Mr. Mitchell, if your assertion is that everything that Mr. Bailey is asking about here has what I heard you say is that everything he's asking about has previously been produced.
Largely, yes, Your Honor. The only caveat, I think in looking through the emails that he produced, the only one that in looking back, we did not produce specifically, and there may be more, but I think that the key one here is the first one that he had in as the first email that he pointed to on his screen. And from what we could tell, that was an email sent from the personal email of a board member who I believe might even be a former board member at this point, who sent it in a personal capacity, to another tenant regarding leaks. But for the large part, I mean, in our exhibit, I believe it's exhibit 1 to our response pleading, in the email chain, you can see where he says, I want emails related to units 1, 2, 6, 7, 21, 23, 25, 34, and 36. And I think other than all of those, maybe minus one, we did have emails that we did produce to him. And so that's why we quickly found out that he hadn't actually accessed the discovery that we produced, I think in August of August 2nd. And that's what he had indicated to us, at least. And that's what the going back and forth on with kind of the production was regarding. And that's kind of where we have here. So I want to make clear that it's not a blanket, listen, we produced every single one. That one email I know we didn't have because it was from a personal email account, but for the large majority of all these other ones, for the search that we did, we produced everything we had. And after this dispute came up, we asked our clients to do, again, another comprehensive search. And we, to err on the side of caution, we produced everything that we found in that search, even if it was duplicative of what we produced originally, just because of the way that they have these emails saved throughout several servers and email accounts. It's tough to get them all together and in one place. So yes, it is our argument that largely we did produce all of the complaint emails that plaintiff is seeking.
Okay, all right. So is there any law, does anybody have any law on how documents are to be produced? The Civil Practice Act may be catching up with technology, but is there any law that says that it has to be paper or has to be digital, or can be paper or can be digital? That seems to be the second issue.
What the law says is that I have the right of inspection and copying of those documents. And that's one of the things that Mr. Mitchell left out of his statement to the court, is I specifically requested to come to his office, inspect and copy at my expense all of the documents that are relevant that I'm requesting. He indicated that would be too time consuming for him. And so he wasn't willing to do that. The statute clearly states that I have that right to come inspect and copy those documents. And that's what I offered to do, again, at my expense. And let me clarify something, one other thing that Mr. Mitchell said. He said that he had turned over documents and that this email was from a personal email of the board member who recently left. It was only just a month ago that board member left. In fact, the board members always use their personal emails. They don't have a board email address. So every email that they produced were all from personal email accounts. And if I could show the court one other email, it's actually the chain of the email that I showed the court before. If I could share my screen one at a time, it shows that in fact, other board members were on that email. So if I could.
What would the defendant have these though? I mean, are they in the custody, possession, and control of the defendant? Access?
They should have been, because yes, if you look at this, if you could see the screen, Your Honor,
sure.
It says here, C. Wilburn at Access Management. This is the same email chain, right? And this is both, they represent both Fair and Walker and Access Management. So if you look there, Rodney 9 at Hotmail is the board member that then, I guess, sent a subsequent from that same chain to the email, to the individual that we were discussing, that first email. So all of these email addresses that originated from that email that went to everybody, and neither one of the emails were produced. So to say that this was just from a personal email from a board member in a personal capacity is disingenuous, because here, the same issue, the same email chain that highlights the same issues, these emails weren't produced either. So it goes back, those 200 emails that were produced, none of which were produced, and they all came from the same source.
Okay, Mr. Mitchell, do you have any law, or are you familiar with anything that says that once you comply with discovery digitally, you don't have to do anything else?
I think he's correct in indicating that he has the right to inspect. But that's what we offered him. We said, listen, you are perfect. Come to our office. We will inspect it on the thumb drive. We will give you the thumb drive and go from there. I think that what he had requested was he wanted us to print out every single of these 1,000 of emails And then he would then make copies of that. Again, that's kind of the onerous part of it. I think I'd have to get the exact site, but my understanding is that as the code is kind of updated, as you said, with emails and electronic, they said that that is a perfectly fine substitute for paper copies. I didn't see anywhere when we were having this discussion back and forth with Mr. Bailey that indicated that it had to be produced in hard copy form. You know, and again, if it was a couple, you know, dozen pages, it wouldn't be an issue. But these are thousands of individual emails that would have to be individually printed and then individually stacked. And to date, Mr. Bailey hasn't given us really, I mean, I haven't really received a reasonable excuse for why he can't accept them in thumb drive or why he can't accept them via secure link or some kind of cloud-based system when he says that he's accessed the first production that way, and why all of a sudden now it's now not possible for him to do so. So again, I think that we have a duty to cooperate in good faith with producing discovery, but at a certain point, you know, it's abusive litigation to demand things that are unreasonable. And I think that, I mean, I think he was, I wasn't a part of the first case, but I thought he was sanctioned for abusive litigation in the first case as well. And so I understand that he's pro se, and I understand there's a lot of documents and we're doing the best we can, but at a certain point I have to protect the interests of my client as well. And it's just, it's getting very tough to do.
Okay. What's the second issue? I mean, we have another motion. Whose motion's that? That's a motion for protective order. Quash subpoena. Is that you, Mr. Sauls?
Yes, Your Honor. Mr. Pankey is going to be arguing it, but Larry, we're not able to hear you. You're muted or something.
All right, Mr. Pankey, you want to argue your motion? Uh-oh. We can't hear you. Okay. Mr. Mitchell, Mr. Sauls, who does Mr. Pankey represent?
Your Honor, he's here on behalf of Fair and Walker, the association. Another attorney with the firm, but given the fact that I'm the subject of the motion, he's going to be the one arguing it.
Okay.
Okay, Your Honor, Mr. Pankey is going to be here in my office.
I sit down.
Yep.
Try it again. Good morning.
That works much better. Okay, Mr. Pankey, you want to go forward?
Yes, please, Your Honor. Mr. Bailey has filed multiple lawsuits, multiple genres. We are now even a defendant in a federal proceeding that he's filed against our law firm. I see that he's pro se, but I suspect he's had some legal training. And I would request the court to ask him, did he ever learn that he's not just supposed to violate the attorney-client privilege?
Okay, we're way on beyond that, Mr. Pankey. We're several years ahead of you. Keep going.
So as to the attorney-client privilege, the things that Mr. Sauls is hired to represent Fair and Walker for are exactly the things he wants to talk about. And
Does that excuse him from sitting down, being put under oath, and asserting that privilege?
It does across the board when that's what his entire claim is about.
Well, just answer that question. I mean, I have people all the time, either in discovery or on trial, who take the stand, take the oath, sit down, and then from there on out, it's an assertion of either constitutional privilege or statutory privilege. So yeah. I don't want to make work. I don't want to, but I want a good record. So tell me why he doesn't have to show up at all.
Well, we filed a motion for protective order, and we've not even been served with a subpoena. So it's to get the court's attention that this deposition should not occur at all. And the reason it should not occur is if you read his complaint, he's trying to prove notice to Fair and Walker through notice to the attorneys. That's not how you provide notice of damage to his unit to Fair and Walker. Anything he says to us is not relevant or admissible under 9/11/26.
Well, how has he noticed the deposition, or has he? And
he requested it.
How?
And I believe he filed a subpoena after we had filed for a protective order, pointing out that he had not filed.
So originally he just sent a notice of deposition on February 27th?
I believe that is correct.
Okay, and you're saying that's not good enough? He had to subpoena Mr. Sauls
I believe he
individually?
did have to subpoena him, correct.
Okay, and has he done that since?
He has done that since,
Okay,
and we filed a motion for protective order.
okay. So what do you want me to do?
I'd like the court to quash the subpoena, and as well as a notice deposition, that there's nothing admissible to be attained in this deposition, and that there is no discoverable information from the attorney for the defendant in the case. It is a pattern of behavior that he takes on the attorneys for his misdeeds. That is a pattern. The court is aware of this. He's sued us in federal court. Now he wants to depose the attorneys in the case that he's losing it. It's absurd. He knows better.
Okay, well, that's the absurd defense. Okay, Mr. Bailey, what do you want to ask? What do you want to ask Mr. Sauls?
So the testimony from Mr. Sauls is extremely relevant because they filed a counterclaim. That counterclaim consists of attorney's fees, calculation for association fees, and several costs. Mr. Sauls has indicated several times to this court that he's responsible for doing all of that. He's responsible for calculating the association fees.
Why can't you take the client's deposition?
Because Mr. Sauls has specifically indicated that he has handled that portion.
Was Mr. Sauls a party?
He wasn't, no ma'am, but he from the beginning of this issue, even prior to the litigation, Mr. Sauls indicated to me that I was not to reach out to the client anymore. Every communication needed to go to him, right? And as such, even when I hired an attorney to speak to Mr. Sauls about the calculation of fees, Mr. Sauls could not come up with how he calculated certain fees. That issue is still in dispute with how those fees were calculated. The only person that can determine how the fees were calculated is Mr. Sauls. The only person that could determine how the attorney's fees that they're seeking in this matter was calculated is Mr. Sauls. The only person that could determine how the costs were derived and how they included it in the filing is Mr. Sauls. And lastly, on several different occasions, I reached out to Mr. Sauls about notice regarding the dispute resolution process. Those emails were sent to Mr. Sauls, who indicated he would then contact the board regarding the notice that I had provided to him. The deposition testimony is simply to ask Mr. Sauls, did he receive information or notices from me that satisfy the dispute resolution process in the Fair and Walker Community Declarations. Those issues can only be answered by Mr. Sauls because he's the individual that had the direct communication and direct access to the information.
Okay. So Mr. Pankey, the attorney's fees, I'm assuming that you have counterclaimed for, are not liquidated at this time. That is an ongoing issue, correct?
Your Honor, I will step in here, provide this clarification. Your Honor, the attorney's fees up through January have already been, Mr. Bailey has already reimbursed the association for those because those were included as part of the lien that the court will recall had to be satisfied to stop the foreclosure. So under the voluntary payments doctrine, which I can get the court the site for that, but basically when there's a disputed amount that is owed and you go in and you pay it, that you don't have the ability to recover the amounts that have been paid. So that portion of the attorney's fees has already been paid at this point, as well as the assessments. And to clarify what Mr. Bailey was saying, as far as the firm calculating the amounts that are owed, The association's ledger adds charges that are charged for assessments and late fees. It does not go through and add in the interest on an ongoing monthly basis, just basically because their system's not set up to do that. So the only portion of that we calculate is simply totaling the monthly interest up. As far as the attorney's fees portion, to the extent that those are not liquidated, those are going to continue through the case. And so
Well, that was my question a while ago.
yes, Your Honor, they will continue to accumulate throughout the case. So if he wants to ask me about them, if the court enters judgment in favor of the association on the counterclaim, he'll have the opportunity to do so when I would have to prove that to the court at that time. And, you know, any communication that I had with Mr. Bailey regarding notices being sufficient or not sufficient, obviously those communications speak for themselves.
Okay, anything else, Mr. Bailey?
Yes, Your Honor. One last thing is the association fees that Mr. Sauls just indicated were voluntarily surrendered. That's just simply not the case. When a lien is filed, the Georgia Supreme Court has been clear that that's an involuntary payment of those fees, and that amount is still in dispute. I know they would like to think, well, that issue is over, but it's not. I didn't voluntarily pay those fees. I still dispute that those fees are owed. And so to think that, well, we don't have to discuss that anymore, is just simply not the case. I still want to determine how those fees were calculated, how the association's monthly interest was calculated. Mr. Sauls just indicated he calculated that, his firm calculated that. As such, I believe that I'm entitled to discuss, to ask him questions, how those figures were calculated, how the costs associated with the association fees that they are counterclaiming for were calculated. And then lastly, how the attorney's fees were calculated.
Okay, thanks. All right, Mr. Mitchell and Mr. Pankey, if you want to split this up, that's fine, but please take an order and get that into the court. Copy Mr. Bailey. On issue number 1, the motion, Mr. Bailey's motion to compel, the court is ordering that Mr. Bailey be allowed to go to Mr. Mitchell's office and to go through the jump drive with someone who has knowledge of those things on your computer so that you can show that there is no corruption, then give him the jump drive. You do not have to produce paper copies. All right, on the motion to quash the subpoena on the deposition, that's granted. Mr. Sauls does not have to appear for deposition at this time. When the attorney's fees are put up, he will be subject to cross-examination at that time, but not now. Anything else? Okay. Thank you all, everybody. Have a good day. And I'm going to go ahead and take us off YouTube.